Standing over her, she wakes up and finds her husband in black latex gloves, dressed in all black. Well, let's discuss this with my guest, Julie Rendelman, law and crime legal analyst. You know her very well. And Lateef Gray, welcome, trial attorney extraordinaire. Lateef, let me start with you first. I mean, that seems to me a pattern of domestic violence. We all know that women have a high rate of being killed by the person they love. That love is apparently the motivating effect. Talk to me about the domestic violence here.
Well, it appears that the victim was very scared of her husband and wanted to be away from him permanently because of the history of domestic violence. And the fact that she reported that he was standing over her in all black and wearing latex gloves, that's not a good situation for Mr. Howard. So unfortunately, it appears that there was a history of domestic violence, and that history of domestic violence is being used to prove that Mr. Howard had the character and the traits to commit murder on his wife, which from a defense perspective, this is bad evidence. And from the prosecutorial perspective, this is great evidence.
So, Lateef Gray, all right, if you're the defense attorney, then what is your argument? I want to compare your argument to what they say, obviously, but what would you say to what the prosecution just argued? And I think I heard the word splatter, and everyone who knows me, it's blood spatter, and I almost had a heart attack here on the set. But that being aside, what would you say?
Well, I would agree with what counsel just said as far as the defense arguing that this lady committed suicide, and therefore, if she was planning to commit suicide, then the way the shampoo bottles are facing is irrelevant. The fact that she didn't have a towel is irrelevant because she planned on killing herself. But the one issue that you just discussed is the scientific evidence, which is independent, doesn't support a self-inflicted gunshot wound. Whether it's blood splatter or spatter, it wasn't present, which is what you would expect to see if a gun were fired close range, within inches of somebody's face or head. So I would argue that it's irrelevant that the shampoo bottles and things like that weren't present. But I would also argue that you'd have to find a way to get around this indisputable DNA scientific evidence as well.
All right. Okay, Lateef Gray, trial attorney. Let's talk about this because, as you know, I'm a defense attorney. You now do defense. It seems to me that the affair that was years ago and coming out now would not be, if I'm sitting on the jury, what I'm concerned about with the affair, that the motive and her having the affair would be a motive for her husband to kill her because he was so nuts jealous and he thought maybe it affected his reputation and character in the community. Talk to me about this.
Well, that's the way the prosecutor is probably trying to spin it. But what I think I hear the defense attorney saying is that this affair was coming to light and that because of the embarrassment that resulted therefrom or could possibly result therefrom, the decedent decided to take her own life. Whether that's effective or not, we'll know soon enough once the jury reaches this decision. But I think that's what I hear the defense attorney arguing, that the embarrassment from this affair is what caused the decedent to take her own life. Yeah, if I were the defense attorney, I would have been jumping up and down about that. I mean, I would have argued that there have been many people that touched the body since it was taken from the scene. And the fact that at the scene, they didn't take any photos of these alleged injuries would be something that I would argue to the jury, that there's no way they can link these alleged injuries to my client. And as far as the defense attorney's argument, I think he's doing a very good job. You know, he's being what a defense attorney is supposed to be, which is a zealous advocate, and he appears to be leaving no stone unturned in his attempts to create reasonable doubt.
You have to leave me, so I really want you to punch it out there because I definitely want to hear what you as a trial attorney have to say.
Well, from the defense attorney's perspective, it appears they're trying to make this witness seem like he was coached up by the police to include Mr. Williams in this trial and include Mr. Williams in that 2013 shooting. But he's not being very cooperative. I assume that he knows more than what he's willing to testify about, but since it's an open court, he's a bit ashamed because he's being called as a prosecution witness. So I think he knows more than what he's willing to testify about. But from the defense's perspective, they're trying to minimize his testimony by making it seem like he was coached up by law enforcement to include Mr. Williams as a participant in this previous shooting attempt.
Lateef, I hope you will join me again. I'm going to go now to Julie Rendelman.